Welcome back to our 30-day SHRM-CP exam prep course. It's day 21, and today we're diving into a crucial legal principle that every HR professional must master: employment at will. Imagine this scenario. A manager storms into your office, demanding to fire an employee on the spot, without any warning or reason. What can HR pros like Babu legally do? This is where your knowledge of employment at will becomes your superpower. Let's break it down. The basic rule of employment at will is pretty straightforward. It means that an employer or an employee can end the employment relationship at any time, for any reason, or even for no reason at all. The key phrase here is, as long as it's not for an illegal reason. Sounds simple, right? Well, not so fast. The SHRM exam loves to test you on the exceptions. This is where the concept of wrongful discharge comes into play. Think of it as the safety net that protects employees from unfair termination. There are three major exceptions you absolutely need to know. First, there's the public policy exception. You can't fire someone for fulfilling a legal duty, like serving on a jury, or for refusing to do something illegal that their boss asked them to do. Firing them for these reasons would be a clear violation of public policy. Second, we have the implied contract exception. This happens when something, maybe a statement in the employee handbook or a verbal promise made during an interview, suggests job security. For example, if a manager says, "As long as you do good work, you'll have a job here for life," that could be interpreted as an implied contract, making it harder to terminate them at will. Third, there's the implied covenant of good faith and fair dealing. This is a bit more complex and isn't recognized in all states, but it's vital for the exam. It basically means neither party will do anything to unfairly deprive the other of the benefits of the employment agreement. Now, let's put this into a classic SHRM exam scenario, just like Babu faced. A company decides to fire a senior employee just 1 week before their pension is fully vested, citing restructuring as the reason. Red flags should be going up everywhere. Babu immediately recognized this as a high-risk situation. This action looks like a clear attempt to avoid paying out the pension, which directly violates the implied covenant of good faith and fair dealing. The timing is just too suspicious. By advising against this termination, Babu protected the company from a costly wrongful discharge lawsuit. So, let's recap the key lesson for today. Employment at will is the general rule, giving employers flexibility. However, as a strategic HR partner, your job is to ensure that every termination is legally sound. Always double-check that the reason for termination doesn't violate public policy, break an implied contract, or breach the covenant of good faith and fair dealing. Great job today. Babu successfully navigated a tricky legal issue, protecting both the employee's rights and the company's interests. Tomorrow, we kick off week 4 and dive into the numbers side of HR with Sequence 22, HR metrics, and the real financial cost of employee turnover. Thanks for learning with us. If you found this helpful, please hit that like button, subscribe, and turn on notifications so you don't miss a single day of our 30-day journey. See you tomorrow.